I'm just going to explain what copyright is all about. But before I do that, because you'll notice that copyright is just a branch of what we call industrial property. Kuna kitengo ama kuna part ya sheria inaitwa intellectual property. Intellectual property ni jina broad na inamaanisha mali. Just like any other property, intellectual property is property. So utaweza kuwa na gari, that is a property. Utaweza kuwa na shamba, hiyo ni property. Utaweza kuwa na ngombe unakamua pale kwako, that is property. Something that you own, that you have a name in it. Kitu itaweza sema, hiyo kitu ni yangu. That is intellectual property. So intellectual property is intangible in nature. Unlike hiyo ngombe unakamua, ama hiyo shamba unaenda kulima, ama hiyo gari unaendesha, intellectual property is intangible, ni kitu huwezi guza. But ni creation of your mind that has value. Kitu utaweza tengeneza pesa nayo, kama hiyo content yenye our friend ametuambia. So copyright is just one of the two branches of intellectual property. So intellectual property is the broad term that refers to intangible property. Property yenye huwezi guza, but ni mali, iko na value in it. Na inatokana na akili yako. Kuna kitu utaweza kaa chini utengeneze, useme, naweza tengeneza, ni kama nini sasa? Utaweza tengeneza a machine, for example, yenye itaweza fanya kitu na haijaifanywa, for instance. When you create that particular machine, that is an intellectual property. But iko kwa branch ingine tunaitanga industrial property. So intellectual property iko na branches mbili. Iko na industrial property na iko na copyright. So industrial property applies in industry and commerce. Ni vitu hizo machines ama kitu tutaweza tumia in commerce. Kama dege. An aeroplane, when it was created, it has intellectual property in it. Something like this microphone I'm holding has intellectual property, has industrial property in it. For example, it could be a patent or something else. So industrial property, iko na types. There are several types of industrial property. One of them niyo nimesema, patent. A patent applies in industry, like I've said. It is an invention that solves a technical problem. It is a solution to a technical problem. Like, for example, the other day I saw there is a Kenyan who is trying to create a voting, counting or tallying machine. That machine, akiweza kuitengeneza, that would be a patent if it has not existed elsewhere, because it solves a technical solution. Gari iko na parts which are moving. All those ones are patents. Then tuko na trademarks. A trademark is a name or a logo or a combination of names and logos zenye zina identify a product or a service as belonging to a person or a company. Like tumesikia hapa kuna watu wako na majina zao za stage names. Those stage names mtu ataweza protect kama trademark. Kama trademark, wasanii ni wangapi? Nani muziki ako na stage name? Mmoja ako na stage name. By the way, niko na deni yako sasa because you answered my question. Si ndio? Tutapatana kando. Aya, msanii ako na stage name. I want to use a stage name that, yeah. Your stage name is, mpatie microphone. We just hear the stage name. There is a gentleman up there. Bazo Bazo. Good. So Bazo Bazo is not his real name. It is a stage name. Ni jina anatumia kuuza usanii wake. So akitoa ngoma, aseme hii ngoma imetolewa ama andike Bazo Bazo. Utajua hiyo ni that name identifies that song as belonging to him. There is a catch in trademarks. Na hii ndio ina distinguish between industrial property na copyright. Hiyo Bazo Bazo, kama huja register kama trademark, you are not protected. Mtu mwingine ataweza tumia hiyo. How do you register? I'm not going to give so much details on that because kazi yangu ni copyright. But for trademarks, for you to be protected, you must have registered that trademark. You register through an institution we call Kenya Industrial Property Institute, KIPI. Kenya Industrial Property Institute, KIPI. Alafu mnaandika because I know most of you have trademarks. Umesikia trademarks kama Churchill Show. Churchill is a trademark. Huwezi kuja hapa uanze kusell kutumia Churchill, whatever it is already registered. Mliona nani, what was his name? There is a gentleman mwenye alikuwa ameregister trademark, alafu one of the telcos wakatumia hiyo in selling their products. And he went to court, Willis Raburo. And was paid a lot of money, millions of money, because that telco had used his trademark without his consent. So it is very important, ladies and gentlemen, for you to register your trademark with the Kenya Industrial Property Institute. You want to find out how? Go to the website for KIPI, utapata hata the amounts that you pay. It is not a lot, but I don't know the exact. It could be less than 10,000, but you'll find out in relation to that. I needed to spend a bit of time in trademark because it applies to you. So I talked about patents, industrial innovations that solve a technical problem, a solution to a technical problem. Trademarks, I've said, are those signs, logos, names, or a combination of those that tend to identify a product or a service as belonging to somebody. Then we have industrial designs, which we say they protect the aesthetic feel or look of something. Like, for example, your kitty, ikakuwa na specific design. That design can be protected as an industrial property. Again, all those ones I mentioned, zina protectiwa na KIPI. Then I go to our business of the day, ladies and gentlemen. I said, intellectual property iko na industrial property na iko na copyright, sindio? So what is copyright? Is any industrial property which I was mentioning? You can have a look at them. What I didn't mention is geographical indications, which identify something as coming from a particular region because it gets a unique taste because of the climatic or basically the climate of that particular area. Like I know hapa nimetafuta kitu inaitwa mishebebe. Sijapata. Kama kuna mtu ataniambia kwenye nitapata mishebebe. Stoki place kama sijakula. Sijui kama I'm pronouncing it rightly, but I'm looking for mishebebe. So, and I'm sure it has a unique taste because it comes from here. Then we have trade secrets. Copyright relates to original creations of the mind, such as kitu umeandika, literary work, musical works, audiovisual works, artistic works, and broadcast. So copyright is different from industrial property in this sense. For industrial property, I've said one of the things is that for you to get protection, lazima ukue register. Copyright, you don't have to, but it is a creation of the mind that protects the expression of the idea. We are going to show, I'm going to show you shortly about that. But ideally, ina protect vitu kama literary works, kitu umeandika, musical work, muziki definitely, audiovisual work, these are films and the like, or artistic works, which are photographs and similar things. So you get copyright inakupatia exclusive rights. Exclusive rights is inamaanisha ati ni wewe tu utaweza exercise hizo rights ama ni wewe utaweza authorize mtu mwingine kutumia to exercise those rights on your behalf. Na ku-authorize means either licensing anakulipa ama unauza. Ukiangalia sheria article 40 of the Constitution, that is where we get the mandate to protect intellectual property, and that includes the copyright. When you look at that article, it says that the state shall promote and protect the intellectual property of the people of Kenya. Intellectual property, tumesema, includes copyright. So there is a constitutional requirement that the state protects copyright. So it is a constitutional right for your copyright to be protected. And of course, we have the Copyright Act. You can look at that act. And then we, in the international platform, we have the Berne Convention. Berne Convention, because I know somebody may ask this question. Berne Convention, it is an international convention that lays down the international standards, the minimum standards that could protect copyright works, or basically copyright works. Berne Convention is a convention in which Kenya is a member to. The membership is basically all the United Nations member states. I think, as you may know, I think there are only 3 countries which are not members of the UN. Only just 3. So it means kazi yako itakuwa protected internationally, because Kenya is a member state of the Berne Convention. Kazi yako ikikuwa infringed in Uganda, ikikuwa infringed in the United States, ikikuwa infringed in elsewhere, then you are protected. You can take action. And I'm going to tell you how you can take action. And if I forget, just note that as a question. Because how do you enforce your rights which have been infringed out of the country? Copyright protects the expression of the idea, not the idea. Kuna watu wanakujanga wanasema, mimi niko na idea, nataka kuiprotect. Copyright does not protect the idea. It protects the expression of the idea. Kama uko na idea kwa kichwa yako, hiyo si protected ikiwa kwa kichwa yako. Ama ukikuja uniambie your idea na niende nifanye, copyright will belong to me. Your idea is not protected because you cannot have monopoly in an idea. There is something we call idea expression dichotomy, which means that copyright protect the expression of whatever it is that you have created, but not the idea behind it. For example, I'm going to give a very good example. Acha nitumie a mobile money transfer. Tunakuanga na mobile money transfer options, where utaweza transfer money from one mobile number to the rest. That is the idea. That is the basic idea. Safaricom wako nayo, Airtel wako nayo, Equitel wako nayo, and other banks, they have it. Notice, anybody can have or can create a mobile application that transfers money from one number to the other. But you cannot copy venye Safaricom wametengeneza. Huwezi copy M-Pesa, huwezi copy ile Airtel or any other bank, because they have expressed it in a certain way. But your idea is not protected. Again, wewe ni musician wa gospel, unataka kutoa wimbo based on, I don't know most of the biblical characters, I'm going to be honest. I think it has been years ever since I went to church, for good reasons. But I know there is a character called Job. So, Job alikuwa na story yake, he suffered, alikuwa na diseases. Alafu, I think, if I remember my CRE, I think alipona, I don't know what happened. But assume, there is that story in the Bible. There is nothing that prevents one person kutengeneza wimbo ama story ya Job. Ukitengeneza yako in a certain way, doesn't prevent me or somebody else expressing the same idea in another way. Sio idea ya the story iko protected, it is the expression. Uko na wimbo, unataka kutoa wimbo, wimbo ni gospel ama tuseme tu ni ya mapenzi. Msichana walipatana na kijana, wakikula mishebebe, wakapendana, wakaendelea kula mishebebe for the rest of their life. That is the story. Utaweza tengeneza story kama hiyo. Nothing prevents me from mimi pia kusema, okay, kuna msichana wa kutoka Nyeri, alikuja huku akakula mishebebe, akapenda, akarudi, akapikia bwanake, wakapendana. So, the idea behind the whole thing, watu kupendana because of whatever it is, doesn't prevent somebody else from creating a storyline based on the same, as long as you copy your work. So it is the idea that is protected. So for copyright to exist, it has to be original. Lazima ikuwe si copied. You should not copy for it to be protected as copyright. By original we mean it must not be copied, and again it must be expressed in a tangible format. Tangible format is the one that can either be touched, that can be viewed, or one that can be felt. For example, a photograph. Ukipiga picha, hiyo picha, it qualifies for copyright as long as you have taken it. Ama kama unaandika blogs, once you type in your computer, that is when the work becomes protected, not before you express it in a tangible format. Tangible format means it can either be seen or it can be touched, like a sculpture, like a writing, like a music, you can hear it. So once that is done, then it qualifies for copyright work. Tumesema sana in general that what you should do for you to get that protection as a copyright. But what are these works? Ni kazi gani ina qualify kama copyright? Mtu asikuje na ati ametengeneza akona, what example can I use? Let me just go through what I have, then we can think of an example. But what is in this list is what qualifies for copyright protection. We have artistic works. Artistic works includes such things that I've listed there, including photographs. So a photograph, ukipiga picha, hiyo picha is an artistic work na iko protected. Ukiweka mtandaoni, wewe ndio uko tu na rights zenye tutamention, and it is only you who can authorize any other person from exercising those rights. A sculpture, umechonga kitu, then you have copyright in that particular sculpture. A drawing, kuna watu wanakuwa very good in drawing cartoons. Those cartoons or whatever drawings that you do, whether you are doing it with a pencil or you are doing it on a computer, that drawing which you have done in a computer or on paper is an artistic work that qualifies as copyright. Literary works. Literary works includes things like books, magazines, lyrics, and most importantly, there is something we call computer programs. Computer program, ukitengeneza computer program, what is protected is the source code. The source code is what is copyright protected, and you can always submit that for registration in the Kenya Copyright Board. Scripts, anything that is written, either in words or in figures. Good, that is what we do in court. When you're passing before the judge, you bow. Thank you, sir. Musical works, hamkuona hiyo. A musical works is simple. Musical works is basically music. These musical connotations are those ones that are registrable as musical works. Sound recordings, hizi ni vile zitu, unaona vitu zinakuwa kwa skiza tunes, ama callback tunes. Ukipiga simu unasikia mtu akisema kajoke hapo. That is a sound recording. So sound recording is not necessarily music. It can be music, but it includes the spoken word or even somebody reading something or quoting something or saying something. That is a sound recording, qualifies as a copyright work. Audiovisual works includes things like films or music which has been recorded in audiovisual format. Dramatic works such as choreography, dance moves, martial arts moves. This is a new addition which was added in 2019. It wasn't there in our law, but we added it. We haven't seen anybody registering this choreographic work as copyright work, but they are copyright work under the Kenya copyright work. So if you have unique dance moves, and I've seen people with very, very unique dance moves, which actually can be copyrighted. You know these salsa dances, there are those people who even train for it. Those ones are copyright works which can actually be submitted for registration, but then you wonder, how do you submit for registration? There are people who actually have dance moves in drawings. They can draw dance moves. And we have seen even in martial arts which can actually qualify for copyright work. Broadcast protect the signal. Remember, ukiona kazi imekuwa a film, for example, audiovisual work imekuwa broadcast. There are two things at play there. Kuna the content, which is the audiovisual work, and then kuna the broadcast. Broadcast is the signal, which is protected under copyright. Of course, that is owned by the broadcasting organization. So you need to distinguish those two. When there is a broadcast and the content. And I always tell people, particularly creatives, they have a lot of power which they don't know. A broadcast cannot work without a work. So nyinyi muna create work, nyinyi muna make your broadcast exist. So you have a lot of bargaining powers, but for some reason you just don't use that power. But a broadcast cannot be useful without the content. The content doesn't need broadcast. You can always use it in some other ways. Now that we know what is a copyright work, ni hiyo kazi umetengeneza, your creation, original creation of the mind, that has not been copied and that has been expressed. Could be a writing, could be audiovisual work, could be a musical work or other works that we have mentioned. Who owns that? Before I delve into that, I want you to notice, I've been talking about rights. Naongea juu ya rights. Naongea juu ya haki. Siongei juu ya kazi, ni haki. Because there are two things. There is the work, and then there are the rights. Let me use an example of, what can I use? A photograph. A photograph, kuna ile the physical, kuna ile, just something like that one. That is a physical thing. That is there. However, there are rights that are within that particular photograph. So if, for example, mimi ni create a photograph or a drawing, nikuuzie, kitu nimekuuzia, depending with our contract, it's not my rights. I've sold you the physical work. So nikikuuzia, you don't have the right to reproduce. You don't have the right to resell. You don't have the right to create a derivative work out of my work. So distinguish the two. Kuna hiyo kazi na kuna rights zenye zinaendana na hiyo. Let me go back in history. Kitambo, if you are as old as me, which I highly doubt, tulikuwa tunatengeneza films, una record film, then you have the physical thing, call it a CD or whatever it is. Kuna hiyo physical thing. So, umetengeneza wimbo, umeweka kwa hiyo CD. Ukiuza, hujauza rights, umeuza hiyo CD. You as the owner, mwenye ameimba hiyo song, you still own the rights. I know you guys probably still use the CDs. Ukiuzia mtu CD, umemuuzia hiyo CD, hujamuuzia rights. So hana haki ya kwenda ku make copies, hana haki ya kwenda ku reproduce, hana haki ya kufanya hizo rights zenye uko nazo. That is why we delve in and ask, then who owns the right? Rights, you as a copyright owner, you own the right as the author. So the bottom line is that the creator, when you create hiyo kazi, in this case the author, is the first owner of the work. Wewe mwenye umetengeneza wimbo, umeenda, tuseme you are producing on your own, because I'm going to explain the difference. Unaenda kwa studio, unaproduce wimbo yako. Umeandika wimbo yako, na umeproduce your wimbo. You are the author. So you are the first author and the first owner of that copyright. Wewe uko na hizo rights, which actually are part of the that content that you have created. There are exemptions. Assume wewe umeandikwa kazi kwa studio, ama umeandikwa kazi place kama hii. Kazi yako ni ku create content. Unalipwa every month or every week or whatever. There is a contract of employment. Job description yako ni ku create content, kupiga picha, ku create audiovisual content, ama any other thing. That work that you create as an employee belongs to the employer. We are clear. We are saying the creator of a work is the original, the first owner. But if you are employed, that work belongs to the employer. Another thing, if it is work, there is a work we call work for hire or commissioned work. If kuna wedding mahali, ama kuna disco matanga mahali, umeambiwa we kijana kuja utuchukulie video, ama upige picha kwa hiyo disco matanga, tutakulipa 10,000. You have been commissioned to take the photo or to take the video. So ukishalipwa, hiyo kazi inaenda to the person who commissioned you. Mwenye alikupatia hiyo kazi kuchukua video ama kupiga picha kwa wedding, kwa hiyo harusi, huyo ndio mwenye hiyo kazi. Bora tu amekulipa, but that is subject to any contract. Contracts are very important. Kama uko employed somewhere, ama it is work for hire, umeitwa kwa harusi uandike, upige picha. Kama kuna contract yenye inasema hiyo kazi ni ya mtu fulani, then the contract takes precedent. Ladies and gentlemen, I repeat again, contracts are very important. Every time unaenda kwa harusi, unaitwa kwa harusi upige picha, ama you sing, ama you do something else, ensure kuna contract. Indicate, because utaweza itwa kwa harusi hata kuperform. Alafu ukiperform, kuna mtu anachukua hiyo video. Alafu akichukua anaenda anaweka kwa YouTube. Then the question is, who owns the copyright? Of course, you, the owner of that song, owns the copyright. But then, kama kuna contract, and you authorized that person to use your work in a certain way, then unapotelea. So ensure that whenever you are engaging in any activity of creating content, ensure kuna contract. Again, read that contract. See what you are giving up or what you are retaining for yourself. Are you allowing this person to publicize your work? Are you allowing this person to resell your work? Are you giving up all your rights in that work? Ensure you read that contract, because contracts, ladies and gentlemen, are very important. Okay, I thought I had put it in my pocket where we come from. It's possible. Now, so contracts are very, very important. So ensure penye una engage, hata kama ni rafiki yako, actually, especially if it is your friend, especially if it is your brother or your sister, especially more so if it is your father or your mother, ensure mmeandikiana. Most of the complaints we get are not between strangers. They are between close friends. Close friends, relatives, umesema, tuenda tu studio tutoe wimbo, alafu, kuna haja ya kuandikiana, sisi ni mabeshte. Mnaenda studio, mnatoa ngoma, then that ngoma inakuwa hit. It is generating millions. Watu wakiona pesa hapo tipo wanakosananga. So wanakuja kwetu wanatuambia, nilitoa ngoma, huyu mtu ananilipa 20%, ama hata anilipi, so na niko na rights. The first thing we are going to ask you is, wapi contract? Then ukisema hakuna, becomes very difficult. Hata ukienda kotini, the court will ask, what did you agree and where did you sign? So ensure. It is not, kama ni rafiki yako, si ati mtakosana juu ya contract. Contract is important to just be clear on your rights, or to be clear on what you have agreed, because people forget. People forget. It is always good to write it down and ensure what rights are you giving each other. Now, the idea behind intellectual property is ni kuensure ati wewe mwenye umecreate hiyo kazi, si umetumia pesa yako, si umetumia your time. Sheria inasema it is only fair that you be allowed to benefit from your creation for a limited period of time. Ukisha benefit, you have made enough money, then the public should be allowed to use your work. So copyright, just like any other intellectual property, of course, other than trademarks, is limited. The protection is limited for a period. So the copyright duration under the Copyright Act, if it is artistic work, if it is musical work, or if it is literary work, you are protected for 50 years after the end of the year in which you die. Umepata hiyo? Kama umetengeneza muziki, kama umetengeneza kitabu, kama umetengeneza an audiovisual literary work or musical work, hiyo kazi ni yako, na bado ukikufa, God forbid, remove that, God forbid, you'll all die anyway. So then you are still protected 50 years after that. I know the question in your mind is, then nani anakula hizo pesa? Of course utaweza achia your dependents. It becomes, kisheria tunasemanga, becomes part of your not matrimonial, it becomes part of your property after you die, which is subject to distribution after death. So the persons you leave behind can actually continue benefiting for an additional 50 years. They can protect that work for that 50 years. And we have a lot of Kenyan works where the authors or the right holders have died, but their descendants or their dependents are continuing to benefit even up to now. So audiovisual works, kama ni film, photograph, ni 50 years from the year it was created. Of course, we are trying to amend the law and ask, why should it be that? Why can't it be based on the life of the author? We are looking at that in the amendments. Sound recording, the same, but it's based on the year in which, the end of the year in which the recording was done. Broadcasts, there is a good reason, because a broadcast, in most of the cases, these broadcast signals, they are owned by organizations. na hizi kampuni, they can exist indefinitely. And that is not the idea behind intellectual property. Intellectual property inasema it must come to an end, then the public must benefit. But companies, because they can exist indefinitely, we say it is 50 years from the first time it was broadcast. Then what happens once time ikiisha? Once the term of copyright ends, the works falls into what we call public domain. Public domain means that the term of protection has come to an end, and therefore any person can use that work, or copyright has been given up. So when you see a work that is online, it is not necessarily that is in public domain. Public domain in terms of copyright inamaanisha that work copyright may expire, and it can actually be used without reference to the author. Na kuna kazi mingi zime, I don't know whether you remember, there was something we used to call Popeye, the guy who used to, a cartoonist who used to take spinach, Popeye. That fell into public domain this year. So that is something you can take up. Create your music using that. There is a version. That Tom and Jerry also fell into public domain now. That is something you guys can pick, create content. There is a version that is still protected, but there is a version that is in public domain. So you can actually use that to create content. Uko na haki gani kama wewe creator wa copyright work? Hapa ndipo mlikuwa mmesema mnataka kujua haki zenu. Haki ya right holder, kuna haki mara mbili. Uko na economic rights, haki za kutengeneza pesa, na moral rights, which you carry throughout your lifetime or until the copyright expires. So easy rights, they are economic in nature, and they allow you to make money out of it. The right to reproduce, you have the exclusive right to reproduce your work. Venye tunatumiananga kazi kwa WhatsApp, hiyo ni wewe tu unaweza authorize. So if you don't authorize, then you can actually, it is actually an infringement. Right to distribute either by way of sale or for hire, it is only you who can do that, or make money out of it. You can authorize somebody else to do that, and they probably pay you. Translate from English to Kiswahili or any other language. It is only you who can translate your work. It could be a song or something else. Publicly perform, kuna watu wamekuja hapa, they performed their songs. If ikiwa hiyo song si yako, just know that then you have infringed, because it is only the right holder who has the right to authorize or to perform that work. And by authorizing, I mean you can make money out of it. The moral rights, in other words, the other right, which is moral right, are paternal in nature. They are personal. So they refer to the right to be credited as the author of that work, right to be attributed as the author of that work, right to object to distortion. Kama ni kazi yako muziki, utaki ikuwe distorted in any way, you have the right as the author to prevent or to stop or to object to that distortion or force attribution. Right to object to the use of your work in a way that affects your reputation. Assume you are a Muslim, umetengeneza wimbo. You have the right, if you are a strong Muslim, there is a reason why you not used Christians. A Muslim who creates a song, na hiyo wimbo yake inatumika ku advertise a pork joint. That Muslim ataweza object to the use of the song in that way. Right to use a pseudonym, stage name, utaweza tumia your pseudonym, or publish your work anonymously. Kama utaki kutumia jina yako, it is your moral rights. These are rights you can exercise. Even if your work is sold, you can still control those moral rights. Economic rights can be sold or bought, while moral rights cannot be transferred under the Kenyan law. There is that aspect, I say, territoriality and national treatment principle. I'll just mention the territoriality. Copyright, just like any other intellectual property, is territorial. Kila country iko na sheria yake ya copyright. However, remember, nilisema kuna the mother of all, which is the Berne Convention. The member states are the members of the UN, generally speaking. So kazi yako ikikuwa infringed in say, in the UK, you can, your work is actually protected. But you take action based on the law in the UK. You cannot use Kenyan law to enforce your rights in another country because of the principle of territoriality, that copyright, just like any other intellectual property right, is territorial in nature. So mtu akitumia kazi yako bila ruhusa, akikopi kazi yako bila ruhusa, akidistribute kazi yako bila ruhusa, akiperform bila ruhusa, like people we have seen here, akidownload content without your permission, that is where infringement comes in. So infringement is the unauthorized exercise of the exclusive rights of the author. Utaweza fanya nini? You can either seek what we call civil remedies, upeleke mtu kotini, useme unataka akulipe zile damages umesafa kwa sababu ya yeye kushare kazi yako kwa social media. I think that is the common. Ameshare kazi yako, unajua ametengeneza pesa, you can seek for damages out of it. Na injunction, na something we call take down notice, utaweza issue what we call a take down kwa the internet service provider, your platform. Could be Facebook, you can issue a take down, ama YouTube, where that work will be taken down. Apart from that, you can prevent them by injunctive reliefs, and you can seek damages. The other thing you may do is to complain to the Kenya Copyright Board, and they take what we call criminal actions. For criminal action, you will not be paid. This guy, if he is found guilty, he'll either be fined or jailed. This fine will go to the state. Once it goes to the state, then that matter comes to an end, but you can decide that you are going to have both of them run concurrently, or you choose either criminal or civil. There is something called strategic enforcement. It's not all the time that you take action because somebody ame-infringe kazi yako. Tumeona wasanii hawajulikani, but mtu anaenda ana-infringe kazi yao, and they become a hit. Nani alikuwa anajua Kasongo? Hiyo wimbo ya Kasongo. I'm not being political, I'm just giving an example for instructive purposes. Mimi nilijua Kasongo juzi. And now I even know the author of that particular person. Sigejua. Kama yeye angeambia wasitumie wimbo, tungekuwa tunamjua. So you don't take action all the time. You weigh, do I take action on this one, and which kind of an action do I take, or you let it go. We have seen a lot of people who have actually become very famous because of that, of those infringements. Lastly, we have what we call instances when somebody can use your work without necessarily the need of coming to you kutafuta ruhusa. So kuna ile time mtu ataweza tumia wimbo yako ama content yako bila ruhusa yako. Tunaziita exemptions and limitations. The Berne Convention, which I've said Kenya is a party to, says that member states have the right to provide for exemptions and limitations. But of course, once they do that, then they are required to provide for equitable for a remuneration for the right holder, which in this country we have done it through the blank tape provisions. So what are these instances when somebody can use your work without necessarily seeking your permission? If they are using that work for scientific research, they don't have to come to you, as long as, we call these fair dealing provisions. Private use, mimi nimechukua wimbo yako, naisikiza kwangu kwa nyumba, naisikia kwangu kwa gari, ama natumia wimbo yako kwa a family gathering, a wedding, or something like that. That is private use. I don't need your permission to do that. I don't need to pay you. Criticism, umeandika kitabu, umechukua hiyo kitabu, umeona watu wengi criticize content. Mtu ametoa wimbo, mtu anaenda ana create podcast, ana criticize hiyo wimbo, anacheza, ana criticize. So that criticism is allowed through the fair dealing provisions. Reporting of current events, when mnaonanga news media doing. Parody, creating jokes out of content. You have seen people like Paddy doing it, Eric Omodi used to do it. Those ones are protected as fair dealing. Judicial proceedings. Mimi nikichukua, I have, assume niko na an infringement case kotini. Niende nichukue wimbo yako, niende nicheze before a court proceeding. There is no infringement because it is for purposes of judicial proceedings. Nikichukua kitabu yako, ni photocopy the whole of it for purposes of the court proceedings. There is no infringement, ladies and gentlemen. Inclusion of a work in an audiovisual work or artistic work in a public place. Kuna mtu amepiga picha, ameweka drawing, ameweka somewhere in a wall in a public place where anybody can view it. Mimi naenda hapo nataka kushoot video yangu. In the course of shooting, your photography na appear. Then, if it is in a public place, that is not infringement. Another example, there are people, I don't know whether this happens here, but in Nairobi you'll see people performing songs on the streets. So assume somebody is performing a song in the streets, and I've had at least one complaint in relation to that. Then, watu wanakuja wana create a film. In the course of creating that film, that person who is performing on the streets, music yake inaskika. So that is not an infringement, it is an exemption. That the exemptions are limitation because it is in a public place. Una create film again, like in my mention, in a peer, your photograph appears. It is incidental. You are creating a film about a love story, but picha yako behind a long building ni picha ya Raila Odinga. Umechora. Remember that photograph or that drawing would be a copyright work. So it appears in the course of me filming a love story. The love story is not related to that image that is behind. So that is incidental inclusion, and it is not an infringement. Recitation, nikichukua kitabu ama nichukue lyrics zako hapa nizisome, then that would actually be an exemption, as long as it is reasonable. Computer programs, if it is for the purpose of creating a backup copy, or testing to determine whether it is suitable for a certain use, then that would be allowed under the exemptions and limitations. Use for education purposes, where it is used for education purposes by an educational institution that is recognized under the laws of Kenya. If it is not recognized under the laws of Kenya, that would be an infringement. But if it is recognized, a school is using it, then it would actually be an exemption. Libraries and archives, where your work is being used by a library or an archive for purposes of preservation, then that is an exemption that would be allowed. You have been told that there is copyright registration, but I need to mention this as I wind up, that copyright subsists automatically. So once you create your content, that content is protected automatically. Si kama industrial property, si kitu kama trademark, ama kitu kama patent, which you must register for you to get permission, protection. For copyright, you don't need to register. It is not a must. Under the Berne Convention, we have been prohibited to ensure there is registration. There is no need for formalities. So si lazima uregister. However, registration ni muhimu sana for purposes of enforcing your rights and contracting. Watu wenye wako kwa vitu kama YouTube and other places, when there is an infringement, one of the questions will be asked, even in court, utaulizwa who owns the copyright. So it is a matter of evidence. Kama umeregister your copyright, then it will be presumed that you are the owner of the copyright. So for purposes of enforcement and for purposes of contracts, it is important for you to register. Registration as we speak, unless things have changed, is free. If you have your content here with you, you can just pass by that desk and you'll have your work registered. If you have it in a soft copy, and you'll get a certificate within a very short time by following that procedure. You'll create an account on the nrr.copyright.go.ke. You will create, once you create an account, you log in, then you'll fill in the details as required, then you upload your digital work, you confirm your details. Right now we are not charging, but very soon we may start charging, and then you submit and you wait for the certificate of registration, and you will be protected. This part, I'll leave it to my colleague, Madam Sharon, to talk about commercialization. There are different ways in which you can commercialize your work, how you can make money. And I know you are waiting for that because you had asked her questions, pesa iko wapi? So atawaambia pesa kwenye unatoa. So the other elephant in the house is collective management organizations, CMOs. Mnajua CMOs? Mnajua CMO gani? Ama hamjui? Ah, good. I just wanted to see whether you know, to see whether I'll talk about it or I'm going to leave it. But I'll mention what it is about. Now, utakubaliana na mimi, ukishatengeneza kazi, kitu kama music hivi, let me use music, but it could be any other work. Utaweza commercialize, kama Sharon atawaambia, how you can make money out of your work. And one of the ways you can make money is through licensing, but it is very difficult for you to license some users. For example, huwezi enda kwa kila hoteli kusikiza kama watacheza wimbo yako ili uambie wakulipe, ama utaingia kwa kila matatu usikie kama wataimba wimbo yako ili uwalipe. Huwezi sikiza radio all through to see whether they are going to have your song alafu uambie walipe. So what right holders do, they come together, create a private organization, and that private organization ndio ina license these hotels, these broadcasters, these users of copyright works. Alafu wakicollect hiyo pesa, wanatoa the administrative cost, kisheria ni 30%. Inafaa watoe 30%. 70% iende kwa nani? Kwa msanii. Whether that happens in Kenya is another question. So, umeelewa what are CMOs? They are supposed to license your work, collect the license fees, and pay you as royalties after they have deducted the 30%. So they are member organizations. Hizi CMOs zimecreatiwa na members. Nyinyi ndio mna create hizo organizations. Ni nyinyi mnachagua hao leaders. Ni nyinyi mna decides the rules of the game for those organizations. So they are private entities, but they are regulated by the Kenya Copyright Board. The Kenya Copyright Board regulates by issuing a license to them. If they have not complied with the law, they are denied a license. And for those who are following the politics or what is happening in CMOs, the Kenya Copyright Board denied licenses to CMOs because they are not meeting their obligations to distribute the 70%. So they are supposed to be licensed and supervised, and in the course, the current law only allows us to take away their license. And then the question is now what happens beyond that? And we are amending the law to see what happens if a license is taken up. The current status for CMOs I'll just mention, because these are questions that may arise. Kenya Copyright Board did issue a license to one organization called PavRisk to manage all the rights, because all the others did not comply with statutory requirements. Some of them did not pay the application fee, so it denied them a license, gave PavRisk, but they went to court. And there are numerous cases in court which are pending. One is coming up for hearing tomorrow, and we are hoping it is going to go the best way. But we are amending the law to ensure that some of these things are dealt with. So the license for PavRisk which we issued was suspended. There is an appeal that was filed, which is being heard tomorrow. So you'll ask questions if that happened. If your work is infringed online, I'll move very fast, really. There are different ways you can protect your work. There is something we call, people don't know that you can watermark your work as a way of protecting your work, such that once you put that watermark, and the watermark, you can also use what we call digital rights management. That means you can indicate your details on the work, including your contact details. There are countries that respect copyright works, and once you put your details there and they want to use your work, they will ask for permission. So ensure that if you want to, you can use those rights, and also using TPMs, technological protection measures, things like passwords, encryptions, and similar kind of strategies. If your work is infringed online, you can issue what we call takedown notice. When you go to the Copyright Act, it provides for a way in which you can, if your work is being infringed, for example, on YouTube or on any other social media, you issue what we call takedown notice, and you copy the Kenya Copyright Board and the Communication Authority. And the idea is that that person or that platform in which your work is being infringed, they have 48 hours to take down that work. If they don't do that, then there is a liability that falls on them. So I'll actually invite you to look at Section 35B of the Copyright Act to see the procedure for issuing a takedown notice that allows you to take action when your work is being infringed. Kenya Copyright Board, like was mentioned by my colleague, also we do ADR, alternative dispute resolution mechanisms. We do mediation, and we have mediated so many cases. Mediation is the best way to deal with disputes as opposed to going to court. We have realized that most of the creatives don't have money to hire a lawyer. You come to us, we will not charge you. We will try to resolve the dispute we'll try to get in touch with the other person. We'll put you in a table, and we'll have you negotiate. So mediation is just assisted negotiation, where parties are able to negotiate. And we can even do that when you are negotiating a contract, where you feel that the other party has a higher bargaining power than yourself. So if they are willing, you can have both parties come to the table, and we can help you negotiate that contract. Ladies and gentlemen, I rest. Thank you so very much for lending me your ears.